I'll bring in the next set of attorneys.
We're going to hear another case here. Yeah, there we go.
Court is now in session.
The next case is 2020-60906, Mario Benitez-Pinot versus Merrick Garland. Ms. Watson, you may proceed.
I'm sorry. Good morning. If it please the court, my name is Jacqueline Watson, and I am appearing on behalf of petitioner Mario Benitez-Pinot. I previously reserved 5 minutes for rebuttal. This is an immigration case, and Mr. Benitez-Pinot is seeking to review a denial of his statutory motion to reopen filed under 8 U.S.C. section 1229A, subsection B5C. Mr. Benitez-Pinot's motion to reopen was filed under the two sub-provisions of that provision 1229A subsection B5C. He first argued the sub-provision 2, the second one, because it did not place any time restriction on the filing of his motion to reopen, because he did not receive notice of the hearing as contemplated under 1229A1. It was in his argument being that it was not himself that provided the incorrect address, but it was an adult sponsor to whom he was released to while he was a minor. And then in the alternative, he argued under subsection little I, that this failure to appear was due to exceptional circumstances and that the 180-day deadline should be equitably told. And there has been a 28J notice of supplemental authorities filed respondents, to which petitioner has replied. And we both agree that Rodriguez v. Garland is a relevant case that was decided after briefing was concluded in this matter. And at the time of Mr. Benitez-Pinot's motion to reopen and BIA appeal, there was actually binding case law that precluded the argument that was later held in Rodriguez as a result of Nis Chavez versus Garland. And although Mr. Benitez-Pinot's motion was filed after Pereira, but before Nis Chavez and Rodriguez, Mr. Benitez-Pinot did not argue the exact issues precluded by Pierre Paul, but he did argue that the deficiency of the notice to appear, the lack of the address and the time and date and location of the court did affect his diligent efforts to inquire about the immigration case independently from the bad information that he was receiving from the sponsor that was to whose charge he was released. Now, in the original, yes.
Did your client neglect to apprise the immigration court of his address? And under Spagnol Bastos, would that mean that there's no error regardless of whether the notice was sufficient under Nis Chavez?
I would distinguish Spagnol Bastos, because in Spagnol Bastos, the person to whom the NTA, the notice to appear, was served is the one who gave the bad information. At the time, and more like Rodriguez, in Rodriguez, Mr. Rodriguez, when he was served the NTA, the address was valid that was on the NTA. Now, although in this case, the NTA does not contain the address, it's blank. Even though that is true, it is still more like Rodriguez, because at the time he was served the NTA in August 2017, he was in the physical custody of the shelter of ORR. So the address that they would have at the moment of service of the NTA would be correct. It was later, when he was released from ORR, that the sponsor to whom he was being released gave the bad information. But
how old was he then?
He was 16 when he was released from custody.
When he became 18, did he try to clarify this or do anything right
He
away?
did. I'm sorry. Yes, he did. When he would right away when he turned 18, because of the neglect, he was not in a good home. When he turned 18, was emancipated, and he was pretty much released from the ORR requirements of staying with the sponsor. He left, and he went to. He turned 18 in December. He went to see an attorney on his own dime in January 2019. He turned 18 in December 2018. Saw an attorney in January 2019. They told him how much it would cost. He went to work, saved the money, and was able to file it by April 2019.
But did he have a responsibility in the meantime if he knows that they have this wrong address and he's no longer a minor? And in fact, though we have held that the sponsors can find them, other people, parents, not sponsors, but parents or aunts or others they're responsible for that. And you may think that's a harsh result, but we have cases where we bound people by their relatives and other people. But even assuming argument that we weren't going to bind your client based upon those representations here, did he have an independent responsibility to notify of his correct mailing address once it became clear that they certainly didn't have his correct mailing address because he's moved and he knows he's moved?
And that was the problem, because when he found out about the in absentia order was when he found out at the same time that the address was incorrect. And he didn't have a mechanism available to him to, number one, know that the address was incorrect because it wasn't listed on the notice to appear. In addition, he could not call the court directly because the notice to appear was missing the place of hearing. It said to be set. And in all the places where there's a location of the court, it says to be set or redetermined, and the place and time to be set and to be set. So on the face of the notice to appear that he has, there's no indication that the address is incorrect.
But he's also not keeping them apprised. Did he have that piece of paper that said you must keep us apprised? Separate?
Yes.
Okay, because I mean, you didn't have to go to that particular court, because the regulations say that an office, you can report it to an officer, and we've had a case with that too. Unfortunately, we have a lot of these cases, and then reporting it to an officer, you could tell and then it would be on them to make sure it got put in the file.
Yes, but remember, he's released from custody. His sponsor gives an address that he at the time doesn't even realize is incorrect, does not know is incorrect, assumes is correct. They move there, and he actually doesn't move. He leaves the custody of ORR, goes straight to the sponsor, and stays in that same sponsor's home, thinking the whole time the address the sponsor gave was correct.
Okay, I'm sorry. Go ahead with your argument. I had quite a few questions, so I apologize.
Okay, So as I was saying, Mr. Benitez-Pinot did not receive that hearing notice that was issued later, that was first mailed to the correct address at the time of the filing of the NTA, which would have been the ORR shelter, and then later sent to the incorrect address given to the government at release by the sponsor. So Mr. Benitez-Pinot is proceeding and not apprised of that fact until much later. And the decision, the failure to receive the notice of the hearing and know where the hearing was a combination of several factors. But none of them, like the other cases or like Spagnola, for example, in which it was the respondent himself that was the person who gave the false information. In fact, he had no time. Yes.
Ms. Watson, in a broader piece, isn't our law that the error in the address has to have been done by the government? In other words, if he said, I live at 112 Main Street, and they sent it to 412 Main Street, that would be the government's error, and that would be a whole different world. But here, it is not the government's error. They sent it to the address they were given. It was the uncle, lying or whatever. I mean, taking the facts in the best piece to your client, the uncle lying. But if we say, oh, if your uncle lies about your address, then that's not your problem, aren't we going to have a lot of people that want to stay here for years to go ahead and do that? And then when they're finally, because we have had plenty of immigrants who have come here, who have been removed in absentia and do not get discovered until years later. They're, arrested for a speeding ticket. And that's when they try to set aside their absentia. And so if we're going to say, well, your uncle can lie and it's not your problem, that's going to really create a lot of issues. And we've not said that before. We've said quite the contrary.
No.
It has to be the government's error.
Absolutely. Well, it hasn't only been limited. Well, it's also, I wouldn't say limited to the government error. However, it's when one is arguing that there is no notice, there are factors taken into account, because sometimes it comes down to, especially when it's no notice and there's no undeliverable letter as what happened here. And there still have been cases where the address is, it's been alleged that the address was correct, for example, and there is no government error, but there's still find grounds to motion to reopen if the evidence is credible.
The government error there is the mail wasn't delivered. I mean, yes, mail can get lost. I could send you a letter, I could put it in the mailbox and I put the right address and you live at that address and it just never gets to you. We get that. And that's what a lot of these cases are about. But that is not this case. And so let me ask you this. What is your best case for the concept that if there was no government error and no failure of the mailman to deliver, or mail people to deliver, okay, that you can still prevail on that? What is your best case for that proposition?
I'm stuck with a combination of cases, really, because in these motions to reopen, as they look at them in a case-by-case basis, I would probably look at Gomez Palacios and matter of MRA. Although again, not really touching on exactly what we have here, which is why this is a unique argument or I should say a unique circumstance in which, though, the examination of motions to reopen based on no notice are reviewed in a case-by-case basis. And if the evidence is not credible, if the evidence doesn't persuade the immigration judge to reopen, then I think you would avoid that floodgate of people who are just trying to, especially when they're caught years later. That does happen. But in this case, that's not what happened. He went on his own and found this and brought himself to the attention of the government, saying there was a mistake that was not on, there was intentional behavior for sure, but not on his part. And there have been also cases where there's been fraud. For example, like notarios in immigration cases, like when notarios do not deliver an address, or when an attorney doesn't deliver a notice of a hearing to a client. Those cases, there may not be a mistake in the government's part. The notice may have been mailed to the correct address and then delivered, but there's still no notice to the respondent.
What about can you comment on we have our own case, but the government also had a case post-Rodriguez that distinguishes Rodriguez. Did you, for the BIA decision, its name is escaping me at this very second. Do you know what I'm talking about? I'm sure the government will opine on it. You can talk about it on rebuttal if you want.
The BIA case, I'm not aware of.
BIA came out with an opinion post-Rodriguez that said Rodriguez was wrong.
Oh, yes, I am aware of that case. I'm sorry, I cannot remember the name of the case. I am aware of the case, yes. And it's pretty much applying Rodriguez only in the Fifth Circuit, limiting it to the Fifth Circuit.
Even if Rodriguez applies, it would be limited.
Correct.
Not only that, but they say that we should now defer. They've filed briefing in other cases that say that because they have given an opinion that we have to give Chevron deference to that, and that the other opinion was not a Brand X case, and so we don't have to keep with our opinion because it was a clear law in the Rodriguez. You know what I'm saying? So
I do.
What do you have any comment on that?
Well, I
It's okay if you don't.
I really don't have much comment on that, except that I would defer to the Fifth Circuit for at least, in terms of the interpretation. I believe Rodriguez itself gave the Fifth Circuit the opportunity to either defer or interpret the case law as it saw fit, and had every opportunity to grant deference to the BIA should it have chosen. So other than that, I would say that Rodriguez would be the correct interpretation, especially given News Chavez.
Thank you. We have your argument. You saved time for rebuttal. Ms.
Yes,
Aldana.
I did. Correct.
Thank you.
Okay. Thank you.
Ms. Aldana.
Good morning, Your Honors. May it please the Court, Sarai Aldana on behalf of the Attorney General of the United States. The government asked the Court to deny the petition for review as the agency did not abuse its discretion in denying the petitioner's motion to reopen. As an initial matter, I wanted to address the 28J letter that we filed. Though this case involves an NTA that lacks a hearing date and time. Though the petitioner did not challenge the sufficiency of the NTA, the government in all due candor wanted to advise the court of the government's position regarding these recent decisions. However, our position is that Spagnol controls and is most analogous in this case, and Rodriguez does not apply. Like Spagnol, the petitioner here did not provide a valid address, thus he forfeited his right to notice. As a result, any reliance on Rodriguez or the sufficiency of the NTA would be misplaced and inapplicable here.
But they didn't raise Rodriguez, so regardless of how we think Spagnol interacts with Rodriguez, it does not matter here, right? Because they didn't raise the not Rodriguez itself, but the issue underlying Rodriguez.
That's correct, Your Honor. And as I mentioned,
you have to have a correct NTA in one document, and since they didn't, that shouldn't count regardless of the mailing issue. That's the argument they could have made even before Rodriguez to keep it, but they didn't make that argument.
That's correct, Your Honor. But as in all due candor, we wanted to make mention of it to the court and advise the court of our position should the court have that case in mind. So
you're saying even if they had preserved the argument preceding Rodriguez, they can't benefit from Rodriguez because they never gave the correct address, and that's Spagnoli.
And we're talking about Nees Chavez, right? We're saying this is not a Nees Chavez case because it was never argued or presented as a Nees Chavez case.
That's correct, Your Honor. Yes. So turning to the merits of the case, petitioner's motion was undisputedly untimely. Therefore, he was required to demonstrate notice. Here, the agency properly noted that the petitioner was properly served with an NTA. He was advised of his responsibility to update the court with an accurate address. The notice was delivered to the address provided, was not returned as undeliverable. And critically, the petitioner affirms that neither he nor his uncle provided the court with a valid address. And as this court has held in Gomez Palacio, failure to receive actual notice due to the petitioner's neglect to apprise the immigration court with an accurate address does not mean that the petitioner did not receive notice. Petitioner contends that because of his age, then he somehow obviated his obligation. But as this court has clearly stated in Lopez Duvan, the age of requirement or where the duty is imposed is 14 and the petitioner was 16 in this case. Therefore, the agency did not abuse its discretion when it charged the petitioner with proper notice.
So did you agree with oh, sorry, go ahead.
Do you have anything to say? What would you say if someone said this was harsh because the person is, technically a minor under other laws? Is this a harsh result or not really?
No, Your Honor, we wouldn't say it's a harsh result. The petitioner was issued an NTA in 2017, did not take any action other than asking a relative until the beginning of 2019. So we would argue that it was reasonable for the agency to determine that that wasn't sufficient, or his inaction within that time period was reasonable in this case, and it wasn't arbitrary or irrational.
Now,
And
do you agree with my statement of the law that in terms of the wrong address issue, it has to be the government error for that wrong address to matter? In other words, if the government, my example of the 112 Main Street that the government just wrote down or entered in the computer 412 Main Street, that would be a government error, and that would be a different story than we have here, right?
Yes, Your Honor.
Then
That's
the
correct.
issue of not receiving, when there's not a government error, can be the post office issue. You know, the mail person didn't properly deliver, or it got lost at the post office. That also is a separate question, where the person testifies, I didn't get it, and so on and so forth. I was checking my mailbox every day, and my mother went there with me, and all of me, you know, whatever, right? So those are two different worlds, and neither of them applies here. The government error
Yes.
on the address or the post office failure to deliver.
Yes, Your Honor, that's correct, because there was no, the mail wasn't returned as undeliverable in this case. And
I mean,
even if,
along the lines of Judge Haynes' question, does it matter that it was, in a certain sense, the government's involvement in pushing him to his uncle as the guardian, in effect? And so does the government's imprimatur rest on that appointment, or that the appointment of his uncle as the guardian? And consequently, because there is that connection between the obligations that he had and the government, to assign that to the government.
well, no, Your Honor. I mean, because there's nothing in the record that indicates that the government pushed the uncle specifically onto the petitioner. It's just the relative that was available to the petitioner. So there's no action of the government in that sense.
And
I mean,
the government had no part. The government had no part in assigning him to the uncle.
I'm not sure if the petitioner had any other relatives. It may have been that was his only relative available. I think that would be up to the petitioner at that point. I think the petitioner was a minor and was required to be released to a guardian. However, I don't believe that it was the government.
He could have stayed where he was, right?
He could have.
And that was his choice, not to stay there.
Right. Yeah. It's
So
not
the
the
notion-
government's action.
The
As a
notion that he has to,
16-year-old, I mean,
but the notion that he has to live somewhere other than on his own is separate from what happened here, because he could have stayed in that place where he was originally, right?
That's correct, Your Honor. It was the petitioner's decision and the uncle's decision, both mutually, to decide that he would go live with the uncle. In some, it's not the government's action deciding where he lives if he decides to leave the shelter. Even if the petitioner was entitled for notice, which in this case we argue that he wasn't, he still didn't present sufficient evidence to rebut the presumption of delivery. As mentioned, the notice was returned as undeliverable. Petitioner also did not act diligently. As I mentioned, there was no action from 2017 until early 2019. Moreover, the petitioner in his affidavit indicated that he moved in December of 2018 and did not provide an updated address until April. Therefore, there's also a lack of diligence in that aspect.
I mean,
Consequently,
does his youth matter at all in terms of forgiving him for the failure to follow these formalities?
pursuant to this court's case law, at the age of 14, then he carries the obligation to update the court of those formalities and those requirements. Consequently, as the petitioner was properly charged with notice, he was required to file his motion within 180 days. And here the agency, assuming that his uncle's deceit was an exceptional circumstance, still determined that the petitioner did not establish equitable tolling of his 180-day deadline. If there are no further questions, then in sum, the government His position is that the agency acted reasonably in concluding that petitioner did not establish extraordinary circumstances beyond his control, or that he acted with sufficient diligence to warrant equitable tolling. Therefore, the agency did not abuse his discretion, and for such reasons.
May I ask you, what does it matter that as a 16-year-old, he was relying on his uncle to tell him what kind of mail was being received? And at least as far as the case at this point is concerned, the uncle lied to him in the sense that he knew that the mail would never come to him. Does that make any difference?
Well, the agency did consider his uncle's deceit, which assuming arguendo, the agency gave him the benefit of the doubt and said that even if we assume that his uncle's deceit was an exceptional circumstance, to allow him to file the motion within 180 days, petitioner still did not file the motion within 180 days, and did not show extraordinary circumstances to toll his period, which is a higher standard than the extraordinary circumstances.
Why is it not an extraordinary circumstance when his uncle, who was the sole person to whom they were mailing this notice at the address that he provided, and to whom his care the government had entrusted an ordinary circumstance? How was this 16-year-old to ever know when his hearing was to occur?
Yes, Your Honor, but he carries the responsibility. He could have contacted DHS. He could have contacted any immigration court, and he had his A number. He was advised of his responsibility to apprise himself of.
In other words, he could not rely on his uncle, to whom he had been assigned by the government.
Yes, Your Honor, but
go ahead.
Even in his affidavit, the petitioner sheds light in regards to his relationship with his uncle, in stating that it wasn't a good relationship. Therefore, one could imply that he was aware that his uncle probably was not a trustworthy source. Therefore, he should have taken it, upheld his obligation to inform himself by contacting DHS, the immigration court. There's also an EOR portal, which he could have used to avail himself to notice or not.
Do I understand you to say that it's part of his argument that he should at some point understood that his uncle was lying to him when he said that he had not received any mail?
Your Honor, the uncle's deceit was entirely considered within the agency's decision, but pursuant to this court's case law, it's just insufficient to establish that the agency acted arbitrarily or irrationally in its decision.
It's not lawfully in the U.S., right?
I'm sorry?
His uncle was not lawfully in the U.S., correct?
Correct, according to his affidavit.
He knew that.
Right.
Okay.
Right.
Counsel, also, even if you spot him that time period when he was with his uncle, and you do equitable tolling for that time period, it's still he had time after he was already gone, after the 180 days, right? That he didn't, still didn't act, right?
Right. So starting December 2018, when he moved out, he should have apprised the court of his change of address within 5 days.
Oh, well, it's terrible that the uncle didn't do what he was supposed to do, and our case law doesn't put that on the government. But even assuming you're concerned about that, he still had a long enough time period after the fact that he didn't on his own take when he was no longer living with his uncle.
That's correct, Your Honor, that he did not act, he did not file his motion until April of 2019, which was 4 months after he first learned of his removal order, which was in January, according to his affidavit.
Okay, or after he left to live in, was it in November or December?
December.
Yeah, okay. Anything else? Aldana, do you
No,
have
that's-
anything else?
No,
Okay.
that's it for me, Your Honor.
Okay. If there are no further questions, then I think we have your argument. Ms. Watson, you've saved time for rebuttal.
Thank you. I would like to, Justice Haynes, amend or add to the list of cases. And it was in the back of my mind. It's Torres Hernandez v. Lynch, but I believe it's in the material because it's commonly cited as Hernandez v. Lynch. And that would be another case that I would cite as just going beyond the issue of non-receipt, even when there's an undeliverable mail. I would also like to point out that under the regulations at 8 CFR 1003.15 D1, the ones that require the change of notice, once there is a removal order, the court no longer has the case. So after he leaves his uncle's custody in December and goes in January and finds out that he has an in absentia order of removal, there's really nowhere to send a change of address at that point. The case is over. And that's when he starts working on the motion to reopen. And that motion to reopen was filed within the 180 days, which I believe is 6 months. So once he found out the in absentia order in January, and files in April, he is still within the 180 days. And I'd also like to just respond to the issue of his age and Lopez Dubon. The issue of his age is not whether he is old enough to receive the notice to appear. He is old enough to receive the notice to appear, but it is not only his. We're not saying solely his age is the extraordinary circumstance that would toll the time, or that would be sufficient to find that he was diligent in discovering this order. It is just part of it. The disability after age 18 or before, disability minority before age 18 in immigration law and other contexts is considered a legal disability. But again, it is not the only factor that was presented by Mr. Benitez-Pinot. He also presented evidence of mental health issues. He also raised the issue of the neglectful conditions he was living in. And then he also raised the issues that were described in Lugo Reséndez, such as unfamiliarity with the legal system, the inability to find the court because of the lack of information in the notice to appear, his PTSD, and therefore it is not only his age that Mr. Benitez-Pinot is relying on in order to make the case for extraordinary or even exceptional circumstances. And if there's no more questions, I'll go ahead and rest.
Thank you, Ms. Watson.
Thank you.
We've heard both arguments and we appreciate them very much.